A Treatise on the Law of Lunacy. Chapter 1. Definitions. Idiot is defined by Dr. Johnson to be a fool, a natural, a changeling, one without the power of reason. Idiotism is folly, natural imbecility of mind. A man not of sound memory is explained by Littleton to be non compos mentis, a mons, demons, furiosus lunaticus fatuus stultus, or the like. Non compos mentis is the most sure and legal. Lunatic is one whose imagination is influenced by the moon, a madman. Lunaticus, qui gaudit lucidis intervalis, in Beverley's case. Non compos mentis is of four sorts. 1. Idiota, from his birth by a perpetual infirmity. 2. He that by sickness, grief, or other accident, wholly loses his memory and understanding. 3. One who hath lucid intervals, and is therefore non-compos so long as he has not understanding. 4. One who, by his own intemperance, for a time deprives himself of his memory and understanding, as he that is drunken, but this sort of non-compos affords no privilege to himself, or his heirs, and a descent does not take away the entry of the idiot. As lunatics are affected or governed by the moon, so epileptics were anciently called lunatics, because the paroxysms of that disease seem to be regulated by the changes of the moon. Mad persons are called lunatics from an ancient but now almost exploded opinion, that they are much influenced by that planet. A much sounder philosophy hath taught us that if there be anything in it, it must be accounted for not in the manner which the ancients imagined, nor otherwise than what the moon has in common with other heavenly bodies, occasioning various alterations in the gravity of our atmosphere, and thereby affecting human bodies. However, there is a considerable reason to doubt the fact, and it is certain that the moon has no perceivable influence on our most accurate barometers. 1. Made idiot by sickness, which Lord Hale called dementia accidentalis voladventitia, and which he again distinguished into a total and a partial insanity, from its being more or less violent, is such a madness as excuseth in criminal cases, and though the party in everything else be entitled to the same protection with an idiot, and though his disorder seem permanent and fixed, yet as he had once reason and understanding, and as the law sees no impossibility but that he may be restored to them, it makes the king only a trustee for his benefit without giving him any profit or interest in his estate. 17 Edward 2. Ch. 10. 1 BL. 304. Sir W. Blackstone defines a lunatic or non-compos mentis to be one who has had understanding, but by disease, grief, or other accident, has lost the use of his reason, but that a lunatic is indeed properly one who hath lucid intervals, sometimes enjoying his senses, and sometimes not, and that frequently depending upon the change of the moon, but under the general name of non-compos mentis, which Sir Edward Coke says is the most legal name, are comprised not only lunatics, but persons under frenzies, or who lose their intellects by disease, those who grow deaf, dumb, and blind, not being born so, or such, in short, as are judged by the Court of Chancery incapable of conducting their own affairs. Fitzherbert defines an idiot to be one who cannot count 20 pence, or tell who his father or mother were, or how old he is, or that hath no understanding or reason, what shall be for his profit, or what for his loss, but if he have such understanding that he knows and understands his letters, and to read by teaching or information of another man, then it seems he is not a fool nor a natural idiot, which seems more properly to belong to one who has had no understanding from his birth, and is therefore, by law, presumed never likely to attain any. The same rules of judging of insanity, prevails at law and in equity, though Sir W. Blackstone seems to point at a difference, for if a return to an inquisition, state the party to be incapable of managing himself and his affairs, from the weakness of his mind, a commission of lunacy will not issue, the Court of Chancery having never gone further from the ancient returns, which were lunatic vel non, than in allowing returns of non-compos mentis, or insane memories, or since the proceedings have been in equity, of unsound mind, which amounts to the same thing. Non-compos mentis is now indeed the proper technical term, being legitimated by several acts of Parliament. A person born deaf and dumb, is prima facie within the definition of idiot, but daily experience proves him otherwise. Lunacy is a partial derangement of the intellectual faculties, the senses returning at uncertain intervals. Madness is a total alienation of mind. These defects must be unequivocal and plain, not an idle frantic humor, or unrecoverable mode of action, but an absolute disposition of the free and natural agency of the human mind. A memory which the law holds to be sound, is, when a testator has understanding to dispose of, or a mind de superscripto manage his estate with judgment and discretion, which is to be collected from his words, actions, and behavior at the time, and not from his giving a plain answer to a common question. Thus a will obtained in extremis, or upon any importunity, or guiding the hand, may be set aside. 8 Van Abr. 167. pl. 7, 1 Fod. 71. Although courts of equity, in judging upon the point of insanity, are governed by the rules of law, yet if a man by age, or disease, is reduced to a state of mental debility, which, though short of lunacy, renders him unequal to the management of his affairs, the courts will, in respect of his infirmities, if the demand in question be but small, appoint a guardian to answer for him, or to do such acts as his interest, or the rights of others, may require. Lord Chancellor Thurlow said, he was not against the practice of finding a man lunatic who was by the infirmities of age, rendered unequal to the management of his affairs, but the more usual course is to appoint him a guardian, or some person, to act for him in the receiving and managing his property. Weakness is not such a defect as will ground a commission of lunacy or idiocy, for a man may be weak as to figures, and not so as to his estates. Lunacy is a distemper occasioned either by disorder or accident, and to one of these two cases commissions were formerly confined, but at length this part of the prerogative, this paternal care was enlarged and extended to one who is non compos mentis, but here it stopped, and this, at least, a court of equity insists must be found to entitle any one to a commission, and therefore, though a jury find that one is incapable of managing his affairs, yet such a finding is insufficient. They must find him to be of unsound mind. A man may be of weak understanding, and of no resolution of mind, but this is not sufficient to ground a commission, if he never was of better understanding. Perhaps a commission of idiocy might lie, but query, if it be objected that he may be imposed on in disposing of his estate by will, it is answered that fraud and imposition upon weakness is sufficient to set aside a will of real, much more of personal estate. There was a case in Lord Hardwicke's time, where, though one could not be proved a lunatic, yet from the imposition on his weakness, the court relieved against a deed obtained from him, immediately after the decree. The grantee got a release of the decree from him, against this also the court relieved, and it was said, that Lord Hardwicke ordered that he should not execute any future deed, but with consent of the court. A person found a lunatic by a competent jurisdiction abroad, may be so considered in England. But as it is of considerable importance to ascertain, with some precision, the nature of that suspension of general lunacy, called a lucid interval, I know of no writer who has defined it with more accuracy or elegance than Mr. D. Agus, the Advocate General of France, in his pleading in the case of the Princes de Conti before the Parliament of Paris. See Evans's Pothier, v. 2. p. 668. It must not be a superficial tranquillity, a shadow of repose, but on the contrary, a profound tranquillity, a real repose. It must be, not a mere ray of reason, which only makes its absence more apparent when it is gone, not a flash of lightning, which pierces through the darkness only to render it more gloomy and dismal, not a glimmering which unites the night to the day, but a perfect light, a lively and continued lustre, a full and entire day, interposed between the two separate nights, of the fury which precedes and follows it, and, to use another image, it is not a deceitful and faithless stillness which follows or forebodes a storm, but a sure and steadfast tranquillity for a time, a real calm, a perfect serenity. In fine, without looking for so many metaphors to represent our idea, it must be not a mere diminution, a remission of the complaint, but a kind of temporary cure, an intermission so clearly marked, as in every respect resembled the restoration of health. So much for its nature. and as it is impossible to judge in a moment of the quality of an interval, it is requisite that there should be a sufficient length of time for giving a perfect assurance of the temporary re-establishment of reason, which it is not possible to define in general, and which depends upon the different kinds of fury, but it is certain there must be a time, and a considerable time. So much for its duration. These reflections are not only written by the hand of nature in the mind of all men, the law also adds its characters, in order to engrave them more profoundly in the heart of the judges. An action may be sensible in appearance, without the author of it being sensible in fact, but an interval cannot be perfect, unless you can conclude from it, that the person in whom it appears is in a state of sanity. The action is only a rapid and momentary effect, the interval continues and supports itself, the action only marks a single fact, the interval is a state composed of a succession of actions. And to have a sensible proof of this, let us examine the case of those who are only affected upon one or two principal points. One person is always seeing precipices, another supposes the people want to stop him, one transforms himself into a beast, another by a folly still more outrageous, believes himself to be God. If you do not introduce these subjects, they appear reasonable as to everything else. Put them upon these points, they immediately discover their weakness. The madman who believed that all the merchandise which came into the port of Pyram was consigned to him, could still judge very reasonably of the state of the sea, of storms, of signs, from which he might hope the safe arrival of vessels, or apprehend their loss. The person of whom Horace has given so ingenious a picture, who always thought he was attending at a show, and who, followed by a troupe of imaginary comedians, became a theatre to himself, in which he was at the same time both the actor and the spectator, observed in other respects all the duties of social life. Cetra qui vit serverit munia recto amor, bonus sane visnus, amablus hosps, and c. Yet who could suppose that such persons were in a condition to make a testament? If it was true that a proof of some sensible actions was sufficient to induce a presumption of lucid intervals, it must be concluded, those who allege insanity could never gain their cause, and that those who maintain the contrary could never lose it. For a cause must be very badly off, in which they could not get some witnesses to speak of sensible actions. Now, if from thence alone you were to draw the inference of lucid intervals, and supposing them sufficiently proved, should conclude that the testament ought to be presumed to have been made in one of those intervals, there could never be any doubt of success. The consequence would be absurd, the principle therefore cannot be true. You see, sirs, what a lucid interval is. Its nature is a real calm, not an apparent one. Its duration must be sufficiently long to admit a judgment of its reality. Nothing can be more distinguishable than a reasonable action and an interval. The one is an act, the other is a state. The act of reason may subsist with the habit of madness, and if it were not so, a state of folly could never be proved. The nature of mere insanity, which being commonly the effect of temperament, is rather a weakness of organs, an habitual evil, than an accidental malady. It is otherwise with respect to fury, which may have a temporary cause, which is sometimes cured and frequently suspended, and, to make use of the elegant terms of the author of the Factum, distributed by Madame Maidenhems, in 1673, infirmity of mind, particularly when it is the effect of temperament, is not cured by succeeding years. They only serve to fortify the complaint, which may even be considered incurable, being a privation which can never return to being and existence. This was applied to the insanity of the Abbé d'Orléans. Two different states divide all men, if you accept the really sage. The one are deprived entirely of the use of reason, the others make a bad use of it, but there is not sufficient reason for declaring them to be in a state of folly. The one are destitute of the light of reason, the others have a feeble ray, which conducts them to a precipice. The former are dead, the latter ill. These still preserve an image, and a shadow of wisdom, which is sufficient for filling in an ordinary manner the common duties of society. They are deprived of real sanity of mind, but can lead a common usual kind of life. The others have even lost that natural sentiment which binds mankind together by the reciprocal performance of certain duties. Let us apply ourselves to this last character, which is the most sensible of all, and to which the application is the most easy. A sane person, in the sense of the law, is one who can lead a common and ordinary life. An insane person is one who cannot even attain the mediocrity of these general duties. Mediocritatum officiorum turiet vit cultum communum et usitatum. But amongst those whom their weakness places below the last degree of men of common understanding, the jurists distinguish two kinds. The one only suffers a simple privation of reason, the weakness of their organs, the agitation, the levity, the almost continual inconstancy of their minds, place their reason in a kind of suspension and perpetual interdiction, and cause them to have the denomination of menti capti, in the laws, and in the writings of the jurists. In the others, the alienation of mind is less a natural weakness than a real malady, frequently obscure in its cause, but violent in its effects, and which, like a wild beast, seeks continually to break the chains that bind it. And it is this malady which properly bears the name of fury. The former, says Baldus, have an obscure and concealed fury. The latter have a striking and manifest insanity. The last are in a state of drunkenness, of transport, of frenzy. The first approach rather to the state of insanity, an extreme decrepitude. Their reason, like that of an infant or a dotard, is imperfect or worn out, but they are both equally incapable of making a testament, because in the one reason is almost extinct, and in the other it is tied and bound by the violence of their complaint. If these two states agree in this point, they are nevertheless distinguished by separate characters. The state of fury is more violent, but it sometimes admits the hopes of cure. The state of mere insanity is more tranquil, but it is almost always incurable. The one is susceptible of paroxysms and intervals, it rises all at once, it diminishes in the same manner. The other has not intermissions so marked, because the cause which produces it, that is to say, the weakness and debility of the organs, is nearly equal and uniform. Finally, a declared fury is so obvious and evident that it would be superfluous to distinguish the degrees of it, with reference to the incapacity of the testator, because it is certain that all furious persons, as long as their fury continues, are absolutely incapable of making a testamentary disposition. On the contrary, mere weakness of mind is more susceptible of degrees, and of considerable differences. The incapacity increases and diminishes, in proportion to these degrees, and these differences, but who can fix them in general, who can mark precisely the frontiers, the almost imperceptible limits, which separate insanity from sanity, who can number the degrees, by which reason declines and falls into annihilation? This would be to prescribe the limits of that which is illimitable, to give rules to folly, to be bewildered with order, to be lost with wisdom. The doubtful and uncertain point, at which reason disappears, and where incapacity becomes evident and manifest, can only be fixed by the particular circumstance of each individual case.